cannot hear you for some reason. Let me have a look at your...
Can you hear me?
Yes, I can hear you. Please go ahead.
Okay, I got booted out, so I just called back in. Are we ready to go?
Okay. Yes, we're ready to go.
Thank you very much. All right, thank you, everybody. Sorry about the technical difficulties at the beginning there, but thank you all for joining. So as the title of this presentation is The Immigration Law Landscape Under a New President. As you all know, we're having a new president inaugurated in 8 days, and President Trump has already promised to make some changes to the U.S. immigration laws. So we're going to cover up front a little bit about what he's talked about, what he's going to do, and then what he can do on his own, and then what he needs Congress's help to do. So to start off with, I just want to give a brief overview of the fact that most of the U.S. immigration laws are done on a federal level, which involves both Congress and the president signing off on the law. So most of the immigration laws cannot be changed only by the President of the United States, and they need to be changed by Congress, both the Senate and the House of Representatives, passing a bill that then is signed into law by the President. Now, having said that, there are a few things that the President can do without Congress's intervention, and a few of those things Donald Trump has already said he's going to deal with right away when he gets into office. Most of those things have to deal with illegal immigration. President Obama has given the ability for about 1 million people who were brought here illegally as children to stay and get work authorization, and Donald Trump has said that he's going to undo that program once he becomes president. President Obama also has been able to oversee the enforcement of the people who are here illegally. The Immigration and Customs Enforcement, or ICE agency, is the agency that is in charge of enforcing the laws in the United States, and they are the arm of the Department of Homeland Security that does that. The president can direct ICE to set its priorities, its enforcement priorities, and the resources it uses. And over the last 8 years, President Obama has had ICE focus on criminal people who are here illegally and committed crimes, and people who otherwise were thought to be a danger to the United States. A lot of people don't realize that under President Obama's administration, approximately 400,000 people have been deported every year. President Trump has said that the millions more who are here illegally would be deported, but he has since backed off on that, and he said he would focus first on the same types of criminal and dangerous folks that President Obama was also prioritizing. So it's not clear whether there's going to be a significant difference under President Trump as far as illegal immigration. Now, when it comes to legal immigration, there's not a whole lot that President Trump can do without Congress's help. So we're going to go through now the legal and business immigration system that I wanted to discuss. And as we do that, I will talk about things that Donald Trump has talked about changing, and we'll talk about how likely that is to happen under a new president and with Congress's help. So the very first thing that we're going to talk about, which is anybody who's hired in the United States has to go through what's called an I-9 process. And this was implemented in 1986, where employers were given the burden to verify the employment eligibility of every single employee that they hired. And so a form was created for this purpose, and every single employee, U.S. citizens as well, needs to complete this I-9 form upon hire. So here's one of the very first things that Donald Trump has talked about changing in terms of the legal immigration system, and that is there is right now an electronic verification system as opposed to the paper form that we use now. There's an electronic verification system called E-Verify, which as it stands right now, again, is a system from ICE that they have put out there, and it's voluntary, mostly voluntary. Employers can use it, or they can use the paper I-9 system that's existed since 1986, with few exceptions where E-Verify becomes mandatory. Donald Trump has said that he wants to make E-Verify mandatory, And again, this would take congressional input to do that, but most of Congress agrees with this. So any new legislation that comes out starting this year from Congress that deals with immigration most likely is going to put into place the E-Verify as a mandatory requirement, and it's going to replace this I-9 paper form system. And one of the big differences with the E-Verify electronic system is that since every employee gets put into this database, the government has obviously ready access then to check every single employee's legal immigration status. So the following few slides that I'm not going to go into too much detail on, unless there are questions at the end, is the procedure as it stands right now under the current paper form I-9 process. But again, this is likely going to be changed as soon as new legislation goes through, which implements E-Verify instead. So this is the completion of the I-9, which you can look through on your own after the presentation. Now, one of the things that is really important to note, though, is that whether it's the I-9 paper verification or the E-Verify system, it is illegal for an employer to suggest which documents an employee should present. There are very strict laws protecting the nationality and citizenship discrimination, and you cannot elicit more information than is required by law. So what happens is the I-9 or E-Verify gives a list of the documents that would suffice to show authorization to work, and the employee then gets to comply by showing any of those documents, and the employer cannot be more specific or have a preference. And then there's record and documentation requirements under the I-9 system, which again would all change after E-Verify comes into place. There's also penalties for either knowingly hiring or continuing to employ somebody who's not authorized to work. These penalties would also probably all be increased once E-Verify goes into effect, because one of the things that the government has said is that along with this new E-Verify mandatory system, they also want to increase the penalties so that anybody who doesn't comply is going to be more strictly punished. Another part of this process, and again, it doesn't matter whether it's the current I-9 form process or the new E-Verify process, is that a lot of employers want to know up front whether somebody may be needing to be sponsored to work or whether they're eligible to work. And again, due to discrimination laws, there are very specific questions and only very specific questions that can be asked, because if you get too far into the details of asking somebody about their background or history, that can be considered discrimination based on citizenship or nationality. So these offers of eligibility, pre-employment offers of eligibility, there are really only two questions that are permissible to ask to try to get the information that an employer wants. Are you currently legally authorized to work in the United States? And do you now or will you in the future require sponsorship for a work visa? By asking those two questions, most of the time, an employer can find out what they need to find out, whether somebody is hireable immediately or not, because the first question will be answered yes or no on whether they're able to be employed immediately. And then the second question is, even if they have permission to work right now, if that permission is temporary and will expire, they would then have to answer the second question, yes, that they either now or will in the future require sponsorship. So this is how the employers can figure out whether somebody needs to be sponsored to work for them. And it is never required that an employer go forward and sponsor somebody for employment. So if an employer is doing this to weed out potential applicants, they can use this as a legal method to do so, because it is never legally required to go forward with sponsoring a foreign national for employment authorization. So one additional benefit of the two permissible questions that we just looked at was that it eliminates the possibility of future immigration sponsorship, and its policy could be critical based on the job market and would allow an employer to assess immigration sponsorship issues in hiring or retaining foreign talent. And again, this next slide is really about not discriminating and not going too far So I won't go into too much detail about that now because I've already mentioned it, and you can look at that later. So that was just a kind of an overview background of the process for hiring anybody and what needs to be done to verify their employment and what you can ask before you employ somebody. Now I want to specifically get into some of the categories that are used to hire foreign nationals or to enter the U.S. to work. And so what I've listed here are the most commonly used, what are called non-immigrant categories. Non-immigrant simply meaning temporary. So these are all categories that have a finite duration and have an expiration. But these are the most commonly used categories for people to come into the United States and work in the beginning. So we're going to go through these one at a time. So the H-1B professionals is by far the most popular of all of these non-immigrant categories because this applies to all temporary professional workers. And this allows anybody who has a degree, a bachelor's degree or higher, in a field related to the job that they're going to do, to be able to be sponsored by an employer to come into the U.S. to work. You apply for the H-1B in 3-year increments with a total limit of 6 years allowed in H-1B status, with one major exception that deals with green cards that we may talk about at the end. The H-1B also has a labor condition application through the Department of Labor first that we're going to talk about in a moment. So as I said, it's a 2-step process. You have the labor condition application, and then you have the H-1B petition itself. And all of these non-immigrant petitions get filed to the United States Citizenship and Immigration Services, which is USCIS, and again, that is under the Department of Homeland Security. For the labor condition application, the most important thing to know about this is that the Department of Labor wants to protect U.S. workers when an employer is hiring a foreign national. So the employer must make a bunch of promises to the Department of Labor that they're not going to harm U.S. workers by hiring this foreign national. And the first one is really the most important one, which is that the employer must pay the higher of what it pays its own similarly employed workers or what similarly employed workers in the area are paid. And this is what's called the prevailing wage. The Department of Labor has a database with all the jobs in all of the locations in the U.S. And so when an employer wants to sponsor a foreign national for an H-1B, the first thing that we have to do is look up that job in the database and figure out what the prevailing wage is. And the employer has to be willing to pay at least that amount or higher to the foreign national in order to proceed. The Department of Labor actually then gets hundreds of thousands of these labor condition applications every year. And so because of that, they can't go through all of them and turn them around in the 7 business days that the regulations require them to do so. So this is an electronic process where the labor condition application gets submitted electronically to the Department of Labor, and then a computer just looks at the application to determine whether it's completed properly. And if it is, in 7 business days, there will be an electronic certification issued. If the Department of Labor wants to look further into any of these applications, they have the right to do so through an audit after the fact. So now I just want to briefly go over what the requirements are for the H-1B itself once you get through the Department of Labor step of the labor condition application. So the specialty occupation is what's required for an H-1B, which is really the bachelor's degree or higher in a field related to the position to be performed. There's some other definitions that you can use, but that's the one that's the most common. So in this second step, once the employer has done the labor condition application and once the proof has been made that it is a specialty occupation, the employer can submit this entire package to the Immigration Service that shows all of these things. They have the need for someone who is a professional, meaning the job requires someone with at least a bachelor's degree in a field relating to the work to be performed, and that the candidate it seeks to hire has the required degree and any other qualifications required. I just want to make one brief comment about what the degree requirement actually means, because for an H-1B, it's what's called the U.S. bachelor's degree or its equivalent. Its equivalent can be a foreign degree. So any foreign bachelor's degree that is evaluated as the equivalent of a U.S. degree will qualify for an H-1B. Also, an H-1B can be qualified through a combination of education and experience. So anybody who has some education but professional level experience, those can be combined and evaluated to be the equivalent of a U.S. degree. And the rule for that is, for every year of education lacking from the degree, it requires 3 years of professional level experience. So for example, if somebody has 2 years of university level education, if they then had 6 years of professional level experience, that could all be combined to become the equivalent of a U.S. bachelor's degree, and that would qualify for the H-1B. Dependents under immigration law are spouses and children under 21. A dependent of an H-1B gets an H-4 status. They get to hold that H-4 status for the same period as the principal who holds the H-1B. There is no work authorization for an H-4 spouse, but they can attend school, as can the H-4 children. So first now I need to have a little bit of a warning. The approval of the H-1B petition does not necessarily qualify the candidate to commence employment. The employer must verify whether the candidate has been granted a change to or an extension of H-1B status, or whether the candidate needs to obtain an H-1B visa. So what this means in a nutshell is if somebody's in the United States already legally, they can be applied for the H-1B and they can have their status changed from whatever their status is in the U.S. and have it changed to H-1B, so that once the H-1B is approved, they are immediately put into that status and can begin working. For somebody who's outside the United States, getting the H-1B approved by the Immigration Service is only step one. Because they're not here, they then have to go to the U.S. Embassy or consulate in their home country, get an H-1B visa stamped into their passport, and then and only then can they enter the U.S. and begin working in H-1B status. And this is going to be true for virtually all the non-immigrant statuses that we're going to talk about, with a couple of exceptions. If somebody gets an H-1B is what is called employer-specific. It means that the employer is actually applying for permission to employ that foreign national to the Immigration Service. The foreign national actually doesn't even sign off on the H-1B. It's only the employer. Therefore, when an H-1B is approved, the approval is what's called employer-specific, meaning that foreign national can only work for the employer named in that H-1B. If a foreign national gets a job offer from another employer and wants to switch to that other employer, the second employer would have to file an entirely new H-1B filing in order to get permission to employ that foreign national. The good news is that under an H-1B portability law that was passed in 2000, if a foreign national has an H-1B for one employer, upon the filing of another H-1B by a second employer, the foreign national can start working right away for that second employer and does not need to wait for it to be approved. Now, the big issue with the H-1B is the cap. The H-1B category is numerically limited, and this is an area which has been hotly debated and which there's been a lot of talk under the new administration as to what they're going to do. There seems to be a split right now in Congress, where part of Congress wants the H-1B cap to go higher and be more related to the market and what the needs of the market are. And then there are other factions in Congress that want the H-1B numbers to continue to stay limited. So it is unclear at this point whether the numbers of H-1Bs are going to be changed or addressed in new legislation. So for now, what we wind up having is this cap, which is a problem year after year. So right now, as the cap stands, and this, by the way, is the cap as it existed back in 1990 when this category was created. So it's severely outdated, and that's why the number is far less than we need in today's economy. But 65,000 new H-1Bs per year are all that we have under the immigration law as it stands right now. And then in 2004, an additional 20,000 H-1Bs were created for people who have advanced degrees from a U.S. institution. So we only have right now 85,000 H-1Bs per fiscal year, and as we'll see in just a moment, that's not even nearly enough. Now, there are some exempt employees and employers who aren't subject to the cap, and so it's very important to know that because the cap is such a big problem. Institutions of higher education and affiliated related nonprofit organizations and nonprofit research or government research organizations, a lot of teaching hospitals and places like that, for example, all of those are considered cap-exempt employers, meaning that they're not subject to these cap numbers. They can apply for as many H-1Bs as they want whenever they want, and it's not a problem because it doesn't get counted under the cap. An employee, a foreign national, who's been counted under the cap once and has not left the U.S. for more than 1 year, they've been considered counted for the next 6 years because that's how long an H-1B is good for, and therefore they're exempt from the cap. So in the example I just gave of somebody going from employer A to employer B under portability, once they've been counted under the cap with employer A, they could switch to employer B, employer C, however many employers they want over the next 6 years, and they're no longer subject to the cap. So it's just getting that very first H-1B that's the challenge. So this year is going to be the 5th year in a row, because last year was the 4th year in a row, where the 65,000 cap for H-1Bs available during the fiscal year was reached on the very first day of filing. Now, the fiscal year for the federal government is October 1st until September 30th. And an H-1B can be filed up to 6 months and prior to the start date. So for all these October 1st start dates, which is when the new allotment is going to be available, April 1st is the filing day. So everybody files all their H-1Bs on April 1st. So last year on April 9th, because on April 1st they exceeded the cap already, on April 9th, the Immigration Service conducted a lottery to select the sufficient number of petitions needed to meet both the 65,000 and 20,000 caps. They got 236,000 or so petitions filed, again, for these 85,000 slots. So as you can see, the odds, unfortunately, aren't great nowadays in getting an H-1B, even if you file a complete and perfectly valid H-1B on April 1st, because the cap is exceeded on the first day, and so there's this random lottery in order to determine who's going to get an H-1B and who isn't. And this is the problem that we face every year unless Congress decides to raise the cap. So as I mentioned, in 2004, we got the extra 20,000 H-1Bs for the advanced degree holders from U.S. institutions. Because of that, the cost of those extra 20,000 were these extra fees that you'll see listed here, which are pretty hefty, added on to all H-1B filings, and that was what the cost was for getting the extra 20,000. So now the next category I want to move on to is what's called the TN for Treaty NAFTA. Now this one is an interesting one because anybody who paid attention to what Donald Trump was saying on the campaign trail, he talked a lot about pulling out of NAFTA or renegotiating NAFTA and how bad NAFTA has been for the United States. However, he was mostly referring to the trade components of it and not the immigration components of it. So even if he were so inclined to try to do something with the renegotiation of NAFTA, which would be very difficult to do, by the way. But even if he were, it would be unlikely that they would be looking to change the immigration provisions, which are a pretty minor part of the NAFTA treaty in general, compared to, like I said, all the major job and trade issues. So this category, which was created by NAFTA, is for Canadian and Mexican citizens engaged in activities at a professional level. Again, most of the occupations do require a bachelor's degree like the H-1B, but the biggest difference is that a TN is limited to one of the 65 listed occupations in the NAFTA treaty. Self-employment is prohibited, and it does include some positions that wouldn't qualify for an H-1B. The big advantage of the TN over the H-1B for Canadian and Mexican citizens is that if they fall into one of those 65 listed occupations, they can apply for 3-year increments with no limit, and there is no cap, so they can get it whenever they want. For Mexican citizens, they apply at a U.S. consulate in Mexico, and so they apply for the TN visa at the same time as they make the TN application, and then they can get the visa and come in for 3 years. For Canadian citizens, it's even more streamlined because Canadian citizens are exempt from the visa, so they can make an application for a TN right at the border, and if they get approved at the border for their TN, they enter the same day in TN status for the next 3 years. So it's the most streamlined process available. Again, some of the benefits of the TN are no numerical limitations, so that's available after the H-1B cap is reached. You can stay beyond a 6-year H-1B limit because there's, again, three-year increments of TNs indefinitely. And then it may be possible for certain cases where an H-1B wouldn't work. The dependents of a TN are called TD, treaty dependent, and they, again, get TD status for the same period as the principal holds the TN. There is no work authorization, again, but attending school is allowed as a TD. All right, so now I want to talk about one of the most popular categories that of late, especially in light of the H-1B cap. And this category is also extremely popular for people who are working abroad and want to either open up a business in the U.S. and bring themselves and or other people into the U.S. And this is called the L1 intracompany transferees. And so what this is for multinational companies who have an office abroad and an office in the U.S. to transfer employees from the office abroad into the office in the U.S. And there are two types of L1s. There's an L1A for international managers or executives, which is good for up to 7 years. And there's L1B for specialized knowledge workers, which are good for up to 5 years. Again, no numerical limitations, so there's no cap. So anybody who's eligible can file as soon as they are eligible, and there's no worry about the timing. And these are filed again with the Immigration Service Centers. So here are some of the qualifications for L employers and L employees. Again, there has to be a corporate relationship between the employer abroad and the employer in the U.S. So a parent-subsidiary relationship or an affiliate relationship, anything where there's a majority ownership or common control of both the entity in the U.S. and the entity abroad. On the employee side, the employee has to have worked at least 1 out of the last 3 years for that foreign entity abroad as a manager, executive, or specialized knowledge employee, and then must be coming to the U.S. to work as a manager, executive, or specialized knowledge employee. So once somebody has that 1 year of experience abroad, they become eligible to launch an L1 petition, either L1A or L1B. Here's the definition for L1 managers so that you can see what an L1A international manager would be. Here's the L1A international executive. And then here's the definition for specialized knowledge, which is a little less intuitive. But a specialized knowledge worker has to show that they either have specialized knowledge of the company's products, operations, equipment, or other elements necessary for the company to function successfully in the international market, or that they have an advanced level of knowledge or expertise in the company's or organization's processes and procedures. Now, one other thing I want to mention for the L, before I go into the dependents, is that the L1 category is also the most popular category for someone who wants to open up a business in the U.S. who has already a business abroad, because there is a subcategory of the L1 called the new office L1 that allows somebody who, again, has an office abroad where they've worked for at least a year, who wants to open a new office in the United States. And the new office L1 is to allow that person to open that new office in the United States and then come to the U.S. to direct manage that office. And so with a business plan and the ability to afford to pay from that office abroad for the office in the U.S. until that office in the U.S. is financially able to pay for itself, somebody can get an L1 fairly easily to come and open that new office and start working here. So the new office L1 is a very, very popular category for people who wish to open a branch of their office abroad or company abroad in the United States. Last but not least for the L1, again, the L2 dependents. Now, the good news for the L2 dependents, unlike the others we've talked about, is that an L2 spouse can obtain work authorization. So you have the ability then, whether you're being transferred into the U.S. to work for an existing employer, or whether you're coming into the U.S. to open that new office L1, in either of those instances, the spouse on the L2 can get authorization to work. So that is very popular. The next category that is also extremely popular is for people who may not have had the office abroad or may not want to have an office both abroad and in the U.S., so they don't qualify for that L1. But if they want to invest in an office in the U.S., The E1 and E2 are categories that work for most people. Now, the one limitation of the E1 and E2 is that this is based on treaties that the United States has with different countries. So first you have to check if the United States has a treaty with your country, because if not, then you can't do an E1 or an E2. But if there is that treaty, and there's a list of these, you can just Google E1, E2 treaties, and you can find out which countries we have the treaties with. And if we have a treaty, then you can qualify for an E1 or an E2. So an E1 is for somebody who's going to engage in international trade between the U.S. and their home country. And an E2 is for somebody who wants to come and invest in a new business in the U.S. The other nice thing about the E1 and E2 is that there is no limit. So as long as you stay in that status and keep doing that E1 or E2 activity, you can do that indefinitely. You also apply directly to the U.S. consulate in this case. It's one of the few exceptions where you don't apply to the Immigration Service in the U.S. So here's a chart of the differences between the E1 and the E2. So for the E1, for engaging in international trade, again, in these cases, it's based on a treaty, so the applicants have to be from that treaty country. The international trade must be substantial and be principally between the U.S. and the treaty country. The applicant must be in a supervisory or executive capacity, and at least 50% of the stock of the company must be owned by nationals of that treaty country. For an investor, the investor must be, again, from the treaty country. The investment must be substantial and a real operating enterprise. The investor must have control of the funds, and the investor must be coming to develop and direct the enterprise in the U.S. And then here's the big one. The investment must create employment beyond just the investor and family. So to get an E2 approved, you're going to need to have a business plan that is going to show how that business is eventually going to grow to a point where it's going to contribute to the U.S. economy and provide employment beyond just the investor and the family, which again is the goal of most people starting businesses that they're investing in the U.S. And again, E2s are very, very popular in many, many places. I know I'm going through these categories fairly quickly, so if you do have questions, please feel free to type them into the chat window if you have any questions about any of these categories, and I'll get to them at the end. Dependents, spouses and children for E1 and E2 holders. Now, the other good thing about the E1 and E2, like the L1, is dependent spouses do get work authorization as well. It's very common, in fact, for a couple to be coming in to do the E1 or E2 together. So in this case, if one principal gets the E1, the spouse also gets an E1. If the principal gets an E2, the spouse also gets an E2. And both the principal and the spouse are work authorized. So it's very common and very popular to do this with a couple. I just want to also then mention a few other catch-all categories that have been created by various free trade agreements directly between the U.S. and other countries. So if you're a citizen of Australia or Chile or Singapore, there are specific categories that are just for you based on these free trade agreements that we have. They're mostly all professional level categories like the H-1B. Therefore, they require a bachelor's degree or the equivalent. The requirements and procedures are very similar to the TN and H-1B and E categories we just described. And spouses for E3 purposes, Australian citizens can obtain work authorization. That is not true for the H-1B1 spouses for Chile and Singapore. Okay. And then the last that I want to talk about for non-immigrants before we transition to green cards is O. And so O, the way to remember it is O for outstanding. It's really extraordinary ability in the sciences, arts, education, business, or athletics. So if you have evidence of sustained national or international acclaim, and we have extensive documentation to show that, then an employer can sponsor somebody for an O for the period of employment up to a 3-year limit per application, and that can keep going 3 years at a time. So somebody who's truly extraordinary can keep getting O's extended indefinitely. Okay. So now I'm going to transition from the non-immigrant temporary categories to the green card categories, because the green card system is very different, and it is based on these preference categories. So it's not at all like the non-immigrant categories we've been talking about. And again, the idea here is that all of these categories all result in getting a green card, which is permanent residence, which allows people to reside in the U.S. permanently. So all of these categories, the first through fifth preference categories that you see here on the screen, are limited. They all have quotas. They all have caps. So the reason why that's important is because unlike the non-immigrant, where it's only an H-1B cap and everything else isn't capped, for the green cards, all the categories have a quota, and so there's potentially backlogs in every single one of them. On top of the per category quota, there is also a quota for each country. A country cannot use more than 7% of the category quota. And so what that means is for the employment-based categories that we're going to talk about, China and India have been oversubscribed, meaning that the demand for green cards from people who are born in China or India exceeds the 7% that each country is allowed to use. So China and India have backlogs to get a green card in those categories that is even farther behind than other countries. Okay, so let's go through the green card categories, and then we'll go over questions after that. So the first preference category is, again, priority workers, and this covers both extraordinary ability, like we talked about for the O, but this is on the permanent basis. So if an employer wants to sponsor someone for a permanent green card for extraordinary ability, that category exists. And extraordinary ability is one of only two categories in all of immigration law where an employer isn't even required. So somebody who has extraordinary ability can apply on their own for a green card by proving that they have extraordinary ability, which we'll talk about in a moment, and that would allow them to get a green card to stay in the U.S. permanently. The first preference category, priority workers, also covers outstanding professors and researchers, and then multinational executives and managers. Again, multinational executives and managers looks a lot like the L1A temporary category we talked about, but in this case, again, if an employer is willing to sponsor someone for a permanent full-time position, they can get them a green card as a multinational executive or manager as opposed to the time-limited L1. So we're going to go through these in a little more detail right now. So for extraordinary ability, these are the people who are at the very, very top of their field in sciences, arts, education, business, or athletics. No labor certification is required, but they must continue to work in their area of expertise. They must document 3 out of 10 criteria listed in the regulations or other comparable evidence. So I want to just go back now because that, again, if you have that, you don't even need a sponsoring employer. Unlike the other two first preference priority worker categories of outstanding professors and researchers and multinational managers and executives, where you do need an employer to sponsor you. But if you have an employer to sponsor you in one of those, outstanding professor, researcher, or multinational manager or executives, you still do not need a labor certification. And I want to stress that right now because we're going to talk about the labor certification, and you will see what a burden it is to have to go through that labor certification process. And that's why if you fall into one of these first preference categories, that is definitely what you're going to want to do. So now we're going to talk about all the other preference categories. The second preference and third preference categories are ones that require a labor certification, with one exception that we're not going to go into. Fourth preference category is religious workers, which are not very common. And then the fifth preference category are what are called alien entrepreneurs, which some of you may have heard of as the $1 million investor green card. Now, this is something that is also likely to change very soon. And in fact, just today, new regulations were proposed for the investor category that would raise the amount of investment required and would change the process of getting a green card through that category. So because everything is in flux right now, I'm not going to go into too many details about what the current system is for that, because that current system is about to be replaced within the next few months with this brand new system that was just proposed. So instead, what we're going to talk about is for the second and third preference categories where you do need a labor certification, what does that involve? So the second are members of the professions holding an advanced degree or the equivalent. And the third preference category is for professional workers, skilled workers, and other workers. So both of these preference categories require the labor certification process. It's just that the second preference category is advanced degrees. The third preference category is everybody else. So because of that, the second preference category is less backlogged because there are fewer people applying in that category than in the third. So if you're in the second preference category, the backlog is less than the third. And if you're in the first preference category, it's almost never backlogged because, again, there are far fewer workers in that preference category. So if you have to go through the labor certification process in either the second or third preference categories, this is what it is. The Department of Labor will not do a labor certification for somebody unless the U.S. employer sponsoring that foreign national can prove that there are no U.S. workers who are qualified, willing, and able to fill that job. So again, unlike all the temporary categories that we talked about at the beginning, where you don't have to prove that you looked for U.S. workers, you don't even have to try, for a green card in these categories, the second and third preference categories, the employer must try to find U.S. workers and must recruit U.S. workers as if it were an open position. And only if they cannot find qualified U.S. workers are they then able to go to the Department of Labor and ask for a labor certification. So this is the process that they have to go through. They have to do a prevailing wage determination, just like the H-1B. A green card through a labor certification requires the prevailing wage be paid. They have to conduct and complete recruitment. There's an electronic form that gets submitted online to the Department of Labor. The Department of Labor can either certify the application or they can conduct an audit. And in about 1/3 of the cases, they conduct an audit where they want to ask more questions and get more information. If the Department of Labor then certifies the application, then and only then can the employer move on to filing with the Immigration Service. And so the steps finally for filing for the green card itself, there are 2 steps after the labor certification is completed with the Department of Labor. The first step after the Department of Labor is the immigrant petition, where the employer has to show that they have all the elements based on the category proved. They can pay the prevailing wage, the foreign national meets all of the requirements, and then they get the immigrant petition approved. Then, depending on the backlog of which category, again, second preference versus third preference, whether the person is born in China or India or somewhere else, then we'll find out at that point how long the backlog is to wait to transition from the approved immigrant petition to the final step, which is the green card. For somebody who's in the United States, the green card is a green card application called the I-485 filed with the Immigration Service. For somebody who's not in the United States, they go through what's called consular processing, where they have to file for the green card through the U.S. Embassy or consulate abroad. There's advantages of getting the green card in the U.S., so most people prefer to do that if they can. However, it's very important to note that throughout this whole process of the labor certification and the immigrant petition and any backlog that may exist, which could therefore total years, those processes do not give somebody the ability to remain in the U.S. or work unless they have some other underlying non-immigrant category, such as an H-1B, that allows them to continue working while they're going through this process. So that's where that H-1B exception to the 6-year limit comes in. If somebody has an H-1B and has gotten themselves 1 year into this process of the labor certification or the immigrant petition, at that point they are eligible to extend their H-1B beyond the 6-year limit for as long as it takes to get through the backlog and then finally get to the green card application. So that's a very important thing to note. Otherwise, for people who are Ls or TNs or Es or in other categories, they have to be wary of starting the process with enough time to get through the labor certification, the I-140 immigrant petition, and any potential backlogs before they run out of their status. So the non-immigrant status is always the bridge between somebody working in the U.S. and somebody getting the green card based on the length of time it takes to get the green card. So we always look at this whole thing as a continuum. Coming into the U.S., what non-immigrant category makes the most sense? How can you stay and work here while you pursue the green card, and then get to that point where you can eventually apply for the green card, hopefully in the United States. If not, then you have to go outside of the United States and wait until the backlog clears and then apply for the green card through the U.S. consulate or embassy abroad. All right, so I've seen some questions come in, so let me get to those. And if anybody has any more questions, please let me know and I'll get to them. So let's see. So the first question is an H-1B until 2010. So if you've been outside the U.S. for more than 1 year, then you're subject to the cap again. So it looks like then you would have to go into the lottery again. So it's not going to help you to have had the H-1B in the past. Hold on. I just lost the question list. 1 second. What's going on? Let me try to get to the question list again because my chat window just disappeared. Hold on. Here we go. Okay, another question. Manufacturer Australian company introduced the product to the U.S. Here's a good question. So what would you feel is the best way? Find a U.S. partner or go for the new office subcategory of the L1? So there's a few possibilities in something like this. If you want to have the company still running abroad in Australia and then have a new office related to that company in the U.S., then that would be a perfect example of a new office L1 where you would open a U.S. branch or subsidiary of that office and then come into the U.S. to do that work. If not, then a couple other options would be you can either invest in the U.S. business, which would be an E2 possibly, or you could find a U.S. partner, and that U.S. partner and you could form a U.S. company, in which case the U.S. partner would have to be at least a 51% majority owner. So it would be a U.S. company, and then the U.S. company could potentially sponsor you for an E3 if you fall into one of the E3 categories for Australian citizens. So that actually is a good question because it brings up a lot of different possibilities, and it kind of also segues into the next question, which is having a contact with me to go over your situation specifically. And so the answer to that is I do consultations either in person or over the phone, and I'm happy to schedule that with anybody. My consultation fee is $200. It's about 30 to 45-minute consultation, and then we go over any specific questions you have, specific issues that you want to discuss, and if there are multiple options, such as that question that was an example, I can tell you what I think is the best option based on getting the details of your case. If we then decide to go forward with the case, I apply that $200 consultation fee to the case that we move forward with. And so, again, I'm happy to do that if you want to reach out to me by email after the presentation. Then we can schedule a consultation to go over your specific questions. Let me see if there are any other questions. If you set up a factory in the United States, is it possible without a partner, or should we have a partner? So it really depends on, again, if an E2 is possible or an L1 is possible. So if you're doing an office in the U.S. that's a subsidiary or branch of an office abroad, that potentially could qualify as a new office L1, and then you wouldn't need a U.S. partner. Also, if you are coming from a country where we have a treaty and you invest in that office in the U.S., the factory in the U.S., that would be an E2. So you can do an E2 in the U.S. by investing in the factory. Again, you wouldn't need to have a partner. But if neither of those are available, then probably you would need to have a U.S. partner. So so depending on whether you can qualify for the E2 or the L1 would determine whether you would need a partner or not. So that's something we would again have to address the details in a consultation. But we could look into the L1 and the E2, which would not require a partner. All right, I think that's the last question I see here. Oh, wait, there's another question coming in maybe. No, I think, oh, wait, maybe one more question is coming in. Sorry. Oh, yes, I forgot to mention that. Thank you for reminding me. Somebody was asking about fees. So the fees really vary from case to case. I do charge flat fees for almost every case I do because through the consultation I can get enough details to figure out how long it's going to take me and what kind of a case it is. At the end of the consultation, I quote an exact flat fee based on your case. So it's not something that I can give you a quote without knowing the details. So the consultation is what allows me to determine what the fees are going to be for any specific case. The next question is there a restriction on location when registering a company? Is it managed state to state? So for immigration purposes, there is no restriction. So the U.S. Immigration Service doesn't care because, again, it's federal law, so these immigration categories apply equally. However, you do want to look into the different requirements for each state in terms of taxes and other corporate issues, which again are something, and I could refer you to somebody who deals with the corporate and tax issues because that is different from state to state in terms of the laws regarding starting a company. But then once you started the company and registered it in any state, the U.S. immigration laws are the same for every single state. One more question. Should you apply before you do it, or is there a visa where you can test the market with your business idea product? Right, so that's a good question. So unfortunately, there really isn't any way to test the market with your business idea or product and allow you to work in the U.S. The closest to that really is the new office L1, where with a business plan and an office in the United States, and a company in the United States, you can come in and kind of test your idea under that new office L1. But there really isn't a category to allow somebody to come in and just explore things without having something approved first, like the L1 or the E2 in the case of an investment. So I think that's it for the questions. Thank you very, very much. Is there a wrap-up here? So I think that the recording will be available and the slides will be available to everybody after the presentation is over. But thank you all very much for attending.
Thank you very much, Bennett. We appreciate the presentation. We will send a copy of the slides and the video recording of the presentation along with Mr. Savitt's contact details to all attendees. That will go out on Monday sometime. And if you have any questions, please feel free to reach out to Mr. Savitt directly. Thank you very much for attending.
Thanks for your help.